For a valid contract, there must be a meeting of the minds. With one contract, the parties absent-mindedly used a simple phrase for a complicated contract term in Microcapital Investors versus Broyhill Furniture Industries. Broyhill owned a plant and a smaller warehouse that shared a wall and heating system. The system used wood-burning boilers located in the plant. The wood waste from the plant's furniture manufacturing went into the heating system. In addition to heat, the boilers generated energy for the plant's machines. Broyhill sold its machinery to the Whittier Group and the plant to Microcapital. Broyhill kept the warehouse. Section 10 of the agreement stated in part, quote, "Buyer may charge seller 1/4 of the total heating bill for the premises and the leased warehouse," unquote. The woodsmiths leased the plant from Microcapital and the machinery from Whittier. About 4 years later, woodsmiths sent Broyhill an invoice for over $380,000, the apparent cost of heating for the previous 4 winters. Broyhill paid $50,000 and wanted proof of the heating expenses before paying more. Woodsmiths sent a letter showing Broyhill's portion of the heating expenses totaled almost $460,000. Broyhill refused to pay because it wasn't satisfied with the documentation supporting the heating expenses. Microcapital sued Broyhill for breach of contract, claiming it had invoiced Broyhill for almost $475,000. Microcapital argued that the total heating bill included things like fire and boiler insurance, labor, and machinery rents. Broyhill responded that it believed the total heating bill only covered fuel, wages of the boiler operator, and a small utilities fee. Broyhill moved for summary judgment, arguing that the phrase from the agreement "total heating bill" was ambiguous. Microcapital moved to amend its complaint to add a claim for quantum meruit, or unjust enrichment. The court granted Broyhill's motion and denied Microcapital's motion. Microcapital appealed to the North Carolina Court of Appeals.